Good morning, colleagues. Thank you for attending this webinar. For those who don't know who am I, let me introduce myself. I'm Daphne, under the Corporate and Commercial Department division. Right, I'm handling those corporate exercises and also the commercial transactions involving our clients. Now, today I'm going to share with you all a topic on conducting legal due diligence in the context of proposed acquisition of shares, assets, or businesses. Right. This is going to be a short sharing session in which I think is probably will take us around 30 to 45 minutes, right? So without taking much of your time, let me start with the topic, today's topic, right? How do I go to next page? Down. Yeah, nanti. So, okay. I think most of y'all might have heard due diligence. So basically what is due diligence? Now, due diligence basically are most often carried out in a preparation for merger acquisition kind of transactions. You know, this is the first step, where the potential client or potential buyers or investor, when they are going to acquire, enter into acquisition transactions, be it acquisition of shares or assets or businesses, they will do some review on the subject matter. Let's say, for example, if they are going to acquire the shares in the company, right? So then they will have to know more about the company before they enter into the agreement, right? So the three major areas that they will do a due diligence basically are legal, financial, and also tax areas. So basically, the potential investor, they will engage different kind of, the respective professionals to conduct an overview or investigations or review on the company's information. Now, for us, of course, we will be doing legal due diligence because we are in the legal line, right? So for financial and tax also, they will get their financial and tax agents to do it, right? Okay, so what is legal due diligence? Now, the term of legal due diligence is commonly defined as an investigation, review performed. Sorry, to remove this one. So, okay, sorry. What is legal due diligence? Now, legal due diligence is commonly defined as an investigation, review performed, and or research conducted on a company or business asset or a business to confirm the facts of a matter under consideration before entering into an agreement with another party. So the idea behind this investigation is basically to know more about this company or the assets before they sign off any agreement. Right. So by reviewing all these agreements or the information of the company, it gives a chance for the potential investor to know, whether there's any problem with the company or the assets, so on and so on. Okay, right. And then what are the main objective for the legal due diligence, or why is it? Why is a legal due diligence is so important? Now, legal due diligence is important for many reasons, but most importantly, of course, to make informed business decisions. So, by doing the legal due diligence, potential investor or buyer, they will know the value of the business, the company, or the business assets, right? Because when we conduct the legal due diligence, we'll get to see all the contracts of the clients, or the what to call their assets, all this we will know. So from there, roughly we will know, how much assets or how many properties, does this target, they own. So as in, maybe the target, they say, oh, I have this clients, with TMP, or with the Naga, all this, for a potential investor, maybe they will see potential profits or something from all these clients. So from the legal due diligence, the potential investor, they will know more about the target before they enter into the agreement. Now, by doing legal due diligence also, it will help the parties in drafting and for negotiation. So, for example, during the legal due diligence, right, we will know, whether there is any litigation, involving the target, or whether there are a lot of outstanding amounts debts due to these debtors. All this will help the potential investor in negotiating the purchase price. Let's say, for example, they have this a lot of debts, to the creditors, to the clients and so on. So then, it gives a chance for the potential investor to negotiate, for a lower price in buying the shares, or the land, or the assets of the company. Right. So, and also if, say, for example, they have a lot of outstanding tax, so probably the we as a lawyer, we might need to include, some kind of warranties or indemnities in the agreement. Say, the vendor, they have to indemnify the potential investor, right, from all these risks, right? So, okay, this is a second objective. And the third one, identify potential closing problems. So, okay, this one, during legal due diligence, right, we may be able to compile a list of things, for the vendor to do. Let's say, for example, this target is basically a manufacturer. So, a manufacturer, in order for them to run their business, right, they would have a manufacturing license. Say, for example, this manufacturer, they don't have this kind of manufacturing license. So in order for our potential investor to buy this company, they have to make sure that, look, this target, they must have this manufacturing license. So, one of CP in the, the lawyer, of course, they have to suggest to the potential investor, saying that, yeah, you have to have this manufacturing license before we can proceed for completion of the agreement, right? So all these problem or issues found out during the legal due diligence process, they can put in the agreement, right? So yeah, pro tips. This is something like where when you are drafting the agreement, right, between the parties, you can put in a CP as a CP where this CP will be fulfilled once the purchaser, they are satisfied. I mean, as in the result of the due diligence is satisfactory to them. So if, let's say, for example, the potential investor, they find like a lot of issues with this target, and or a lot of non-compliance by this target, so then they can the findings or the result for the legal due diligence is not satisfactory to them, so then they can in a way to exit from this from entering into this sale and purchase transaction. All right. So of course, by doing legal due diligence, some of the seller, they will say, look, now we are going to disclose all the things to you, right, in relation to this company. So of course, they might get the potential investor to sign a NDA, non-disclosure agreement, right? So once you get to know all this information, you cannot disclose within how long, there's a duration in the NDA, all right? Now, next, okay, I'm going to brief you all on the legal due diligence process. So this would, a legal due diligence investigation most likely would take 3 stages, right? So the first one, preparation. Now, different kind of transaction would have different kind of question. I mean, question like we need to tell, basically lawyers, right? We as lawyer, we will need to prepare a checklist, a list of documents or information that you are required for you to carry out the legal due diligence. Now, say for example, the acquisition, the transaction is in relation to acquisition company, right? So you have to draft a list of question or a list of documents that required, in order to for you to determine, what are the, let's say for example, you need to know in and out of the company. You need to know, their corporate info, their property, their insurance, their licenses, all this. You need to cater, cater for different set of questions. Let's say for example, if let's say the acquisition is only in relation to the land, so you have to draft the question is only in relation to the land, right? Okay, so this is a preparation stage where a lawyer will need to prepare a due diligence checklist, and the seller, in order for the seller to prepare, to compile all these documents for your review, right? So the second stage, will be the investigation stage, where once after you have churned out the due diligence checklist, the seller is going to share with you all these documents in accordance with your list, right? So once we have, of course, because most of the time, the seller, either they are not, they don't understand the question that you have raised, or they are just too lazy to just take out that particular kind of documents. So they will dump you all their, the whole bulk of their documents. So from there, we as the lawyer, we need to branch through, what are the documents that are relevant to your, transaction, right? So some of documents which have already been, lapsed or expired, all this, you can put aside, and you ask for the, accurate documents, right? So at the end of the legal due diligence process, you might need to have a big picture of, an overview of the company. Let's say you would roughly know how many assets they have, how many lands they have, where are their factories, what are the licenses that they have, they have already obtained for their business activities, right? So you will have this big picture lah, an overview on the company, right? So, and also during the investigation stage, right? Sometimes we might need to, do some interview with the key management, their CEO or their CFO, to get a clearer picture of the company, because sometimes, in wordings, might not be able to give you a clear answer, you see. So we can conduct an interview with all these key management of the company. All right. So another thing is a site visit. Now, this one, this would help also, because if say, the client, provides you a CF, a certificate of fitness for this factory. Now, the CF basically is stated this factory is actually double story, double story detached factory. But when you conduct this site visit, you go to the factory and you realize, how come this factory, is a 3-story instead of 2-story. So, there is some kind of inconsistency. So from there, you have to, dump question to the seller, look, the CF that you have provided is double story, but then, the actual building is 3-story. So all these are basically reflects, so you have to either raise further question, ask for further documents, or you have to, clarify with the seller basically. So then you highlight all these red flags to your client, okay? Because this is one of the non-compliance also, right? Okay, so results. This is the last steps. After you have reviewed all the documents, right? So then we have to prepare a legal opinion or a due diligence report, right? So, and from there, we might need to prepare a summary, and you have to highlight, your findings of your legal due diligence to the client. And also, the most important thing is you have to highlight all those non-compliances or, those red flags to your client in order for them to decide whether it's a good buy or it's a, bad deal, you see, whether they still want to proceed with it. All right. So I suppose so far so good. All right. So the next things to look out for during a legal due diligence investigation. Now, Now I'm going to tell you all generally what are the things that you need to look out for during a legal due diligence. So then at this stage, right, you have to step into the shoe of the potential buyer. Now, think if say you are the buyer, so what do you want to know about this company, right? What do you want to know about the land that you want to acquire, right? So now I will zoom into like, you know, acquisition of a company. Now, there are a few, you know, sections of for a legal due diligence, right? So now the first one will be definitely corporate information. So we as lawyer, we have to determine, you know, whether determine the legal status of the company, whether it's an existing company or it's a dormant company, or this is already wound up. I mean, the company, the target has already wound up. All this you have to determine. You have to browse through their documents. You have to do, you know, independent searches, right? So, and also to check if there's any non-compliance under the Companies Act in terms of filing of the statutory documents. Because for each and every company, you know, they are governed under the Companies Act. So they will need to file different kind of statutory documents, the annual return, you know, the annual report, or, you know, those forms, the Form 24 to 49, all these forms, you know, there is a timeline, you know, to file all these documents with SSM. So you have to, we as a due diligence lawyer, we have to check whether they are filed in accordance with timelines stated in the Companies Act, you see, right? So if let's say, you know, there's late filing, so is there any penalties, or, you know, what are the consequences of all these non-compliance or breaches? Okay. So the next thing is any preemption rights or consent required for a change of shareholders or control or relating to the acquisition. Now, the shareholders of the target, they might have a shareholders agreement. So we have to review the shareholders agreement to see whether there's any preemption rights. What is preemption rights? Basically, is to say before this seller, one of these shareholder, they want to sell their shares in this target, right, to another party, whether they have to offer this, they have to open this offer to the existing shareholders first. All this we have to review the agreements, the shareholders agreement, right? Okay, the next section will be property. Now, be it the properties owned or leased or tenanted. Now, the target or the seller, you know, they might, you know, represent to the potential investor saying that, oh, I have 5 parcels of lands, and I have 5 factories, all this. So we as lawyer, then we have to verify, we have to confirm whether, you know, the real the registered owner of all these 5 parcels, is it, you know, belongs to the target or not? So maybe we can look at their title, we can conduct land searches, you know, in determining the legal and beneficial ownership, right? So another thing is to determine whether there is any breach under the National Land Code. For example, whether there is any breach of category of land use. Say for example, the title deed you mentioned, oh, the category of land use is meant for industrial, but, you know, the client or the target, you know, maybe they use it for hostel, you know. So this is obviously a breach of category of land use, because the land is meant for industrial, but the target, they use it, you know, for hostel purposes. So all these non-compliance, you have to highlight to the potential buyer, right? So the third one, to determine if there is any breach under the Street Drainage and Building Act 1974. So this is the example that I gave earlier, that the, you know, the target or seller, you know, that they have provided the CF, and the CF is meant for a double-story detached factory. But in fact, you know, the factory, you know, comprised of 3 stories, is it? So all this, they have to either, you know, rectify it, or, you know, because otherwise this will be a non-compliance, and, you know, it will be a what to call an offense under this act, you see, right? So the fourth one, to determine if the land is a Bumi lot or Malay reserve land. Now, if say this transaction is in relation to acquisition of land, right? So it's a what to call a Malay reserve land. So Malay Reserve land, all this, if let's say you are a foreigner or you are a what to call non-Malay, or non-Bumi and buying all this, right? So basically, actually, it's a prohibition. I mean, as in, it cannot. This deal cannot be cannot be go through lah, basically. So all this we need to determine, basically, right? So the fifth one, to determine if there are any onerous terms in the tenancy or lease agreement. Let's say, for example, the target, they have entered into a long-term tenancy, and in the tenancy, they might have a clause saying that, every year the rental, the monthly rental, will be increased 50% from the current rental. So all this for us, maybe, this could be onerous terms. So you have to highlight to the potential buyer, saying that, look, every month or every year the monthly rental will be increased 50% from the current rental, right? So all this you will need to highlight to the potential client, basically. Okay. So the next thing will be on the license. All right, to determine if the company has procured all the necessary approvals, licenses, and permits required for its business operation. Again, like I said, if say the target, is involving in the business of manufacturer, right? So definitely they would have to have the manufacturing license, right? So otherwise they can't run the manufacturing activities, right? And also, like, they have to have a business premises licenses, and the relevant licenses. So before we could determine what are the licenses that they need to procure, right? So as a due diligence lawyers, right, you have to do some kind of research, what are the licenses that, the target probably they will need to have it, procure before they can, carry out the business operation. Otherwise, it will be a breach, right? So, and also to check if all the approvals, licenses, and permits are still valid, renewed, and existing. Okay, so if let's say expired, so the target, they will need to go and renew it. Ask for the renewed certificates or licenses. And then whether there is any breach on the terms of the approvals, licenses, and permits, and consequences of such breach. Let's say, for example, the licenses mentioned that they would have to do a what to call the environmental impact assessment on yearly basis. All this, all the terms in the licenses, the target will need to comply with it. They have to do it, right? And then to determine whether prior written consent is required from the authority in connection with the change of shareholders or control of the company. Now, some of the licenses, right, there's these terms saying that, if say there is any change of shareholders or change in the management of the company, you will need to get notification consent from the authority. So all this, you will need to preempt the potential buyer, so that we can put in the agreement saying that this is maybe this is some of the condition precedent in the agreement before parties proceed for completion of the transaction. The target or the seller, they will need to procure the consent from the authority before they can go ahead with the transaction. All right. So contracts within and not within the ordinary course of business. Now, for this review of review of contracts of the agreement, right? So first of all, you need to determine if there are any onerous terms in the agreement, right? And to determine if there is any commitment on the part of the company, which might reasonably be expected to have an adverse impact on the business, operations, condition, or prospects of the company. And also to determine whether prior written consent is required from the customer or supplier or any third party in connection with the change of all shareholders or control of the company, right? So all these contracts enter into with the customers or suppliers, they might have a terms, a clause saying that if let's say there's any change of shareholders, right? So you will need to notify them or you need to get consent. All this need to be done before, parties can proceed for completion, all right? Now, litigation. Okay. Through the legal due diligence, we might be able to check, whether there's any litigation involving the target, whether there's any pending claim and what is the estimated damage, right? And what are the claims that have been made paid in the past, what types of litigation has the company been involved in, and what are the average damage costs. So all this, is something, that the potential buyer, they will need to know. If say this target, they are involved in a lot of litigation. So, the potential buyer would think, they might not want to proceed with the deal. All right. So litigation also we can conduct, the CITO search or the RAM searches. All right. And we have to read through the cost papers and so on. All right. So insurance. Okay. Insurance, in doing the legal due diligence, insurance, you need to determine if the property or assets of the company is adequately insured. Say for example, the target, they have a factory, doing the manufacturer work, right? So whether they have, as in the company, they have they procure any fire insurance, or burglary insurance, all this to protect the building or the raw materials in the, keep in the factory. So if let's say they don't have it, so what happened if fire, the building caught fire? So it might be, it could be a huge loss, loss, for the what to call the company. So to tell them, oh yeah, the building or the raw material adequately insured, they have insurance to cover, we need to check with the seller and get the some kind of confirmation from the seller. All right. Okay, intellectual property. Now, intellectual property wise, you will need to tell the potential investor to let them know whether the logo, or the marks used in the business, whether they are validly registered. If not, whether it should be, or it ought to be registered. Otherwise, there might be some other third party, they manufacture the same thing, and maybe they are using the same logo, or same trademarks, as per this target, all right. Okay, the next thing, indebtedness and financing arrangement. So again, we need to review the loan documents of the target, to see whether consent is required from the bank before you change of ownership or change of shareholders, right? So highlight to the potential buyer on the owner's terms, right? So what are the monthly installment, or how many loans they have, right? And the employment, to determine the employment terms of key personnel, especially matters relating to remuneration, length of employment, and termination provisions. And what are the benefits of retirement plans, bonuses, insurance offered to the employees? Say for example, they have this employment contract with one of the key management, right, saying that, upon your retirement, we'll give you a $500,000, as a retirement what to call retirement plans, you see, a retirement sum, you see. So this is a huge sum, you see. So the potential buyer might need to know all these things, because these are the future commitment, or that they are liable, you see. They will need to pay in accordance with the contract entered into between the target and also this employee. Okay. All right. Achievement award. To verify the authenticity of the certificate of achievement or award, verifying through the relevant bodies websites. Actually, all this we need to verify the certificate. We need to look at the certificate, and at the same time, some of these relevant bodies, their website, they will have a list of what to call certificate that they have already been so you can check to verify whether they really this target they really have this kind of certificates. All right. Okay, so how long does a legal due diligence take? Now, it depends, you see. So, let's say, for example, this target, right? They have a lot of companies. They have one parent company and they have, 6 to 7 subsidiaries. So, of course, you would need to have a longer time, in doing due diligence on them, because each of the companies, right, we may have to run through all the the different sections that I've mentioned earlier, right? Yeah, we need to run through all the documentation of all these subsidiaries and also the companies in order for us to render a legal opinion or a due diligence report. We need to report to the potential investor accordingly. All right. So what is the cost of legal due diligence? Of course, the more that you do, I mean, the more company that's involved in this transaction, the cost will be higher. All right. So conclusion, do's and don'ts in conducting legal due diligence. Now, first of all, a quick review of material documents. So once you have got all these documents provided by the seller, right? So you have to run through, do a preliminary review on all these documents to check, let's say for example, the constitution, you have to check for preemptive clause, and contracts and loan agreements, you need to see whether there's any prohibition or restriction on change of ownership, shareholding structure, management, and board of directors. And also same goes to the approval licenses, right? So see whether there is any prohibition on change of ownership, and also to see equity condition requirements. Say there is this one equity condition in the license saying that the ownership of this company must be 51, at least 51% owned by Malay, because it's a Malay, it's a Bumi company. So if they say you are a foreigner or you're a non-Malay company, right? So whether it will affect anything or not if let's say you enter into this kind of transaction. Okay, so immediately highlight reflects or issues to client in the course of review. Say for example, got non-compliance or any issues, right? Immediately highlight to the potential buyer, right? So keep client copy in communication with vendor for information. Now, whenever in the course of due diligence, right, we will keep on asking for documents or keep on asking for information. So either by way of email or so all this we need to keep our client in the loop so that they know what are you doing, what have you requested. All right. So read the documents first before reporting. Only summarize salient terms. So you have to read through, browse through the agreement. Don't just simply just copy copy all the terms in the report, right? Okay. So because you need to highlight the issues to the clients first, not to to rush to complete your due diligence report, right? So those are the do's and these are the don'ts, right? So you cannot like take your own sheet time to read the documents and then do up full report before highlighting issues to client. And also to review documents at superficial level, you have to, because legal due diligence, client engages to do legal due diligence, you have to produce a good quality of work. You need to review the documents and you need to think, what they ought to know, what they want to know, you see. You cannot just simply, browse through page 1 to 5 and then the rest you don't review further, right? So you cannot reproduce all the terms of contracts or condition of licenses, wasting unnecessary time, all right? So you only highlight those salient terms, those onerous terms to the client. Okay, so you cannot ignore potential reflex or issue. So you have to have a very clear mind when you are reviewing the documents, or when you are doing legal due diligence, you have to have a very clear mind. All right. So you cannot drag the due diligence. So you have to, do it as soon as possible, so that, because normally in a acquisition kind of transaction, right? Parties will, I mean, the seller, they will, give you a very limited time in doing the legal due diligence, basically. So you have to review faster and report it to the client accordingly. All right. So these are things that, a general review, a general understanding, in conducting legal due diligence. So yeah.